we have amongst us Mr. Balaji sir, advocate on record from Supreme Court, and this is the third part of the Indian Evidence Act he has been taking us through. And today, sir has assured that he will be complete in the rest of the portions. And in fact, it's a privilege to listen to him. The previous two sessions, really many people liked it and had posting me my WhatsApp messages individually. And it is indeed a privilege to have him on our platform. So on behalf of all the participants for joining and the legal delighting, we extend a warm welcome to Advocate Balaji sir from Supreme Court. Sir, the stage is all yours. Welcome, sir.
Thank you, madam. Thank you so much for this opportunity. Good evening to all, one and all who are present here. And we will start our third part of our Evidence Act. I recollect that the last second part we came up to section 78, I think, and it was about up to the documents, the chapter up to the documents, and the proof of the documents we have completed, and we discussed about the public document and what are the documents which are termed as public as far as per the section 74 of the Evidence Act, and we will further continue with from there. We will continue, and though we have to go for the next the chapter or the next the category of the chapter, that is the presumption as to the various document, yet we have to look back from the section 3 and 4 of the Evidence Act. Predominantly the section 4 of the Evidence Act has to be looked into, which is what is presumption, and from where we will again will start and go up to section 165 of the Evidence Act, and the further chapters are the presumptions and the exclusion of the oral evidence by the documentary evidence. That is, only the document alone will speak, and next one is the burden of proof, next one is the estoppel, next one is the who are all the competent witnesses, and next one the examination of the witnesses. These are all the completion examination of the witnesses, which will start from 135 to 167. It will go up to 167, and we will try to cover up the entire thing within the span of about 2.5 hours, and once again we will look back into. I will share the documents from where we will start, and apart from that also I have some charting for you, and so that you can have an easy understanding about the cross examinations and what is the level and the boundaries of the cross examination. And we will first start with I will share the screen. Is this screen sharing is visible, I think?
Yes, sir.
We will once again recollect that what we have come across in the section 4 of the Evidence Act, that is may presume, shall presume, and conclusive proof, and from where we will start, and we will go back, then we will go into the particular section. Before that, we will just look into the rest of the sections which we have been left over. And this public document up to 75, and 74 is the public document, and 75, if you see, that's a private document. What are the documents, public documents, which I already said? What is important thing which the document which are maintained by the public authority primarily the document which are maintained by the public authority are the public documents, and the documents of the sovereign authority, documents of the official bodies and tribunals, public offices. I hope that screen is clear for you now. The public offices, legislative, judicial, executive, the documents which are maintained in these authorities, and the public record kept for the purpose of maintaining the private documents, like sale deed which we are registering and which is being maintained in the sub-register office in the cumulative records, that is, if a copy has been obtained, that is a public document. It will come under the domain of the public document. And the 75 is a private document. All other documents are private documents. What are the documents which are public document? Excepting that, other documents will be termed as a private documents. And if you see the beauty of this public document, the under section 76, if any authority who is in the custody of the public document, he has to on demand produce and furnish the copy of the public document which the person is seeking for it. So this is a certificate copy of the public documents. The right of getting the certificate copy is also given in this Evidence Act. Your right to get the public document from the authority who is holding the custody of the document, this is available under section 76. Every public officer, I am just reading the section, every public officer having the custody of the public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fee therefore, together with a certificate written at the foot of such a copy that it is a true copy of such a document and part thereof. So 74 is a document. 74 documents are termed as a public document which are maintained under the custody of the public authority. Under section 76, you can get the copy of the public document on demand, and it's a duty of the public officer to shall produce a document to the person on the payment of the sufficient fee. So this is what the 76 says. So therefore you can connect the 74 with the 76. And 77, if you come to the 77, proof of the public document by means of the certificate copies. If any proof has been filed, the certificate copy of the public document has been filed, that alone will stand as a proof for the contents of the document. That's what has been. So we have dealt with from the 61 onwards pertaining to the documents, primary documents, what are all the secondary documents, and entitlements of the primary, the proof of the primary documents and the proof of the secondary documents, and the cases in which the secondary documents could be filed under section or proved under section 65 of the Evidence Act. So these were the primary important sections, 5 sections which you have to bear it in mind for the purpose of proving the document. These are all the extensions. Private document, public document under section 74. When public document is when you are entitled to get the copy of the public document under section 76. And 77, by means of the certificate copy of the public document, you can prove the document itself. So such a certificate copy, what is section stipulates? 77 stipulates such certificate copies may be produced in proof of the contents of the public documents or part of the public documents. So you can prove the public documents by means of the certificate copy which is obtained from the authority under section 76. So this is also been linked with the section 79 of the Evidence Act. We will come to the 79 as to the presumption. Once the certificate copy has been filed, the court shall take a presumption on it as to the genuineness of this certificate copy. Cannot be doubted at all. It shall take a presumption as to the genuineness, as to the contents of the document. So therefore, when you start with the 79 to 90 goes with the presumption of various documents which are available for the purpose of proving the fact or any relevant fact. So 79 to 90 speaks of the presumption. Here 77, proof of the document can be filed by the, I think we will not be having any doubt over it, and all the proof of the other documents are also mentioned here. Apart from the public document, the following documents, the acts, other notifications of the central government in its of any department, and the proceedings of the legislature, proclamations, orders, and acts of the executives, and the proceedings and the legislature of the foreign countries, and the proceedings of the municipal body, public documents of any other class in the foreign country. So all these documents are termed as the other official documents, and how the proof has to be given for it. So this is what the section 78 says. Now we have completed the documents and proof of the documents. We will go to the now presumption. For going to the presumption, we will have to go to section 79 to 90 onwards. Presumption of the as to various documents. So fundamentally, before going into this section 79, we will have to go to section 4 first for the purpose of understanding what is may presume, shall presume, and conclusive proof. And along with the 4, you have to keep it in your mind the section 114 of the Evidence Act, the presumption as to the common course of natural event, the presumption as to the human conduct, the presumption as to the public and private business. These are the four things which you'll have to bear it in mind. Court may presume with respect to these four things, which considers having regard to the facts and circumstances of the case. We will go to 114 later, which is a very wide power for the court for the purpose of presuming a particular fact, whether for the facts and circumstances of the case. Okay. Before that, we will go to section 4 of the Evidence Act. May presume, you have to understand the distinction between and the difference between the may presume, shall presume and the conclusive proof. Whenever the court provides that the court may presume, it may either regard such a fact as proved until otherwise disproved, or the court may call for the proof of it. So what this first part of the section, it has three parts: may presume, shall presume and conclusive proof. The first part says, whenever it is directed by the court or provided by this act, whenever it is directed by this act or provided by this act, the court may regard such a fact. Court may, it's not shall, court may regard. Please mind the word here, and the court may regard such a fact as proved. At the same time, the opportunity is also given to the other side to disprove it. Until otherwise disproved, the court shall presume that it is, you may presume it, the fact has been proved. Fact is proved. Or call for the proof of the fact. No, I will not believe that. I will not take a presumption. I will not I will not invoke this section, apply this section for the purpose of presuming it. You provide the proof for it. So therefore, the may is a little weak type of presumption where court may say, no, I will not take a presumption. You provide me the proof for it. So this discretion is also vested with the court here. So may presume is either the court may presume, if it does not have any doubt at all, if that inspires that particular proof of the particular fact, inspires the confidence of the court, it may presume that it is existence, or it may call for the prosecution or the person who is relying upon the presumption, who is in favor the presumption lies, to produce any proof with respect to the fact that is to be proved. And at the same time, it can also give an opportunity to the other side to disprove the fact that is presumed. So what is here? Here, one side it is opportunity is given to disprove, the other side the presumption is also here. Therefore it is a rebuttable presumption. So it could be rebutted. Until otherwise it is rebutted, it could be presumed by the court that it is in existence, that particular fact is in existence. That is may presume. What is the shall presume? Shall presume, whenever it is directed by the court that the court shall presume the fact, it shall regard such fact as proved. It shall regard such fact as proved unless otherwise disproved. The word that is missing is may call for the proof of it is missing. In the first part there is a word, that's the phrase may call for the proof of it. In the second part, that word is missing, that phrase is missing. What is the phrase that is missing? May call for the proof of it. But what is that? Whenever it is directed by this court, that court shall presume a fact. It shall regard such a fact as proved. At the same time, the rebuttal opportunity is given to the other side that unless and until it is disproved. You can also disprove it, but if it is not disproved, then the court shall take a presumption that it exists, that it exists, a mandate on the part of the court, that the court has to presume that the fact exists. This is what the second part of the section 4. Then we will come to the third part of the section 4, that is a conclusive proof. Conclusive proof is one fact is declared by this act to be conclusive proof of another. The court shall, on proof of the one fact, regard the other as proved and shall not allow the evidence to be given for the purpose of disproving it. What is available in the earlier two part, that is missing here. You are not entitled to disprove it, completely shut down. Your right to disprove it has been closed here, but on proof of the one fact, the other fact is presumed. Other fact is conclusive. As term has been taken as it is taken as a conclusive proof of the fact number 1. So birth during the marriage, if you go to 112, it's the best example is 112. So only one example I think that's available there in the Evidence Act. That's 112. Birth during the marriage is a conclusive proof of the marriage. Once a birth has been proved, it is a conclusive proof for the marriage. That's what the 112 stipulates. And the thing is that the baby should have been born within a period of about 280 days. Some condition has been stipulated. This is the section 4. We have to understand before dwelling into this section 79 to 90. You have to understand primarily of this may presume, shall presume, and conclusive proof. In the may presume and shall presume, you have the rebuttal opportunity. In the conclusive proof, you don't have the rebuttal opportunity. In the may presume, the court may call for the proof of it. In the shall presume, the court shall not call for the proof of it. So, from the person who is in favor, the presumption is going to be operated. So, this is the fundamental aspects of the section 4 of the Evidence Act. So, now we will go to the section 79 to 90. So here 79 to 90, they are terming various documents, nothing else. They are terming various documents and presumption, therefore, presumption as to that document. They like presumption as to the certificate copy, presumption as to the, if it is a public document, then the certificate copy will be given, then the court shall presume. I will go to the words later, I will just give an outline of it. First, the presumption as to the certificate copy, presumption as to the record of evidence, presumption as to the certain documents pertaining to Britain, London, United Kingdom and all. Then the presumption as to certain maps and charts published by the authority of India. Presumption as to, most importantly, presumption as to the judicial records or the judicial decisions which you are citing before the court. What is the authority or authenticity that you can give? It is a genuine document. I am citing some ARSC Supreme Court so-and-so judgment, and some judgments are printed there. The court will see that and it will proceed. It is going on the basis of the law declared by the earlier judgment. So what is the authority of the court to presume that it is a genuine one? So this authority is derived from the section 84 of the Evidence Act. Evidence Act gives section 84. Under section 84, court is empowered to presume the genuineness of the records of or compilation of the judgments which are published by the legal publishers, that document publishers, like Eastern Company or something like that. So this is 74. This is 84. Then 85 speaks of presumption of the power of attorney. What is power of attorney? Power of attorneys are nothing but wakalat which you have filed. Nothing but the wakalat you have filed before the court. When the wakalat has been filed, the court has to take a presumption. This wakalat has been genuinely signed by the authority, the persons concerned, like a plaintiff or the defendant or the petitioner or the respondents, somebody like that. So, court never, unless otherwise some doubt created, unless otherwise it is going to be disputed, the court never compares the signatures. But the power of attorney is considered to be, the presumption is to be taken under section 85 of the court shall presume under section 85 of the Evidence Act that the power of attorneys and the wakalats are genuine one. Then 86 speaks of the foreign judicial records. If you cite in foreign judgment, and what is the genuineness of that? Where court whether knows that it's been tampered or not, whether some paragraphs has been altered or not. No, but under section 86 it presumes that it is a genuine one. So therefore we are relying on it. 87 also like that. 89 some varying terms of the contracts are not varying terms. The court shall presume pertaining to the some of the documents which are not been produced. The presumption as to the documents which have not been produced, despite section 66 notice that's been given to the other side who is in the custody of the after compliance of the custody, if the document has not been produced, court shall take a presumption pertaining to the document under section 89 of the Evidence Act. Then section 90 is a presumption as to the documents of 30 years old. Then section 90A is now recently introduced pertaining to the documents of 5 years old pertaining to the electronic records. This is what the outline of this the presumption area. So here genuineness of the certificate copy, court shall, if you see the words here, now we will go by one section, what has been stipulated there. Court shall presume the genuine, to be genuine, every document purported to be certified or certified copy, certificate or certificate copy or other document, which is by law declared to be admissible as evidence, which purports to be the duly certified, which also court shall also presume that it's been duly certified by the officer concerned. So this is what the presumption as to the certificate copies of the public document. So here, as to the genuineness, what is the genuineness of the documents alone is presumed. For the purpose of shall presume, we go to section 4 of the Evidence Act. Shall presume means that until otherwise it is disproved, and until otherwise it is disproved, and the court is giving an opportunity for disproving it also, rebut it also. This is what the section 79 says. Then section 80 says presumptions to document produces a record of evidence. If in the judicial proceedings, if any document is produced pertaining to the record of evidence of the earlier proceedings, then the court shall presume. Here also you see, whenever any document is produced before the court purporting to be the record or memorandum of the evidence or any part of the evidence given by the witness in a judicial proceedings, or before any other officer authorized by the law to take evidence, or to be the statement or confession by the prisoner or the accused person taken in accordance with the law. We will leave all these things. Purported to be cited by any judge or magistrate or such officer aforesaid, court shall presume the document as a genuine. That's it. Earlier also in the certificate copy, court shall presume that certificate copy is a genuine. Like that, if record of evidence is produced, that record of evidence is also court shall take. For that record of evidence also, the court shall presume that it is genuine one. This is what section 80 says. Whenever any judicial records pertaining to the evidence that's been recorded, chief and cross examination, is being produced in any judicial proceedings, court shall presume that this record is a genuine record. Then comes that 81 and 82. I don't think that's relevant for the purpose. It has gone. It is genuineness as to the some of the documents pertaining to the British Crown here and United Kingdom, Queen's printer and all. 81A is also like 81A is presumption as to the electronic forms. Then here 82 also pertaining to the documents of the being purported to the document by law in force for the time being in England, Ireland, etc. England and Ireland. It's something outside. It's not acquired in the practical purpose. I have not seen it. And we'll go to the 83. The presumption as to the map plans made by the authority of the government. So similarly, here also the court shall presume that the maps and plans purporting to have been made by the authority of the central government or the state government were so made and are accurate, and these are accurate. That's like a genuine one. It's an accurate mapping. Map and charts are accurate. So accurate to the extent of this accuracy, the court shall presume that that is a genuine one. So this is pertaining to the section 3. Then comes the important as to the collection of the laws and collection of the law reports of the decision. Law reports of decisions. The court shall presume. I will just read out the section. The court shall presume the genuineness of every book purporting to be printed or published under the authority of the government of the country or contain to contain any other laws of that country, and of every book purporting to contain reports of decisions of the court such country. So this is pertaining to the law, reports of the decisions and compilation of the decisions which we are relying upon in SEC or AAR or SCR or whatever, MLJ or CDJ, something like that. Yes, all these records will be coming under this 84. Court shall presume the genuineness of every book purporting to be printed or published under the authority of the government or to contain any of the laws of the country. So this is how any act, bare act which you provide, or even the collection of decisions you provide, the court shall presume that it is a genuine one. So here next I already discussed. I said that related to the power of attorney, court shall presume. Here also you see that shall presume that every document purporting to be the power of attorney and to have been executed before and authenticated by a notary or any court judge, magistrate, counsel, vice counsel, representative was so executed and authenticated. So this is what the genuineness has been presumed as to the that document, the power of attorney has been so executed and it is authenticated one. Unless otherwise disputed by the other side, or the person who also signed it can dispute it and say that I have not signed it, and unless otherwise such a dispute comes, it's a mandate on the part of the court to presume that it is a genuine one. Whatever the wakalatnama you file, that's you have to genuinely, they have to presume all these things. Okay. Then comes the foreign records. That's in section 86. And before that, we will go to 86, and there is two important provisions as to the electronic records, 85A, 85B and 85C. That's simple as that. It's record agreements pertaining to the electronic agreements, the contract in the electronic contract or electronic agreements, and whatever it is, the signature that's been endorsed in that, the presumption can be taken. Unless otherwise it is disputed, the presumption can be taken. And 85B and C are missing here. It is in the other book. And 85B is also there. You might expect any questions pertaining to this 85A, 85B, 85C. All are similar. There are certain certificates which are given under the authority. Suppose if you take an order from the Supreme Court website, that order and other documents are coming, the entire judgments are being published there in the Supreme Court website. If you see at the bottom of this proceedings order, that's for every hearing or something like that. We can take every hearing order from the Supreme Court website. If you take that order, it is digitally signed. There will be an yellow color authentication digitally signed. It is now, those were the days we used to take the certificate copies for the purpose of sending to the, when I was standing counsel of the government of Tamil Nadu, I used to send it certificate copies. Thereafter, the situation has changed that once you take out the printout from the website, and if it's going to be sent, that it's considered to be the genuine copy of that electronically signed documents, electronically signed records. So these things are coming under the 85 A, B and C. This one is pertain to agreement, and the second one is a certificate that's been issued, and the electronic record and the signature that is endorsed therein in the electronically signed has to be presumed. Third one is the certificates which are given under the electronic authority. Some A and 85A, 85B and 85C. Very simple to read, easy to understand, nothing much to explain about that. And section, we will go to the section now. 86 is also missing here. 86 is pertaining to the foreign judicial records. Presumption as to the certificate copies of the foreign judicial records. Similar to the Indian judicial records, the compilation of the documents, compilation of the judicial authorities, the presumption could be invoked for the foreign judicial records also under section 86. 86 is missing here. And now we will go to the 87. 83 and 87 could be almost similar to each other. The presumption is to the books, maps and charts. The court may presume, here you say that shall is now being changed to the may. May presume that the book to which it may refer for information on the matters of the public and general interest, and that any published map or chart, the statement of which are relevant fact and which is produced for its inspection, was written and published by the person at the time and the place by whom or at which it purports to have been written or published. So, when a book has been given to the court shall may presume that it's been published by the person so endorsed therein. That's it. That's nothing big about it. It's pertaining to the presumption as to the map, presumption as to the books, and presumption as to the chart. The difference is, there it is a government authority. 83 it is a government authority, published by the government authority. It is by the, here it is by the maybe by the private authority. Government authority has been expressly missing here. So therefore we can take it that it's from the any other authority. So then as to the presumptions to the telegraphic messages, earlier we used to send telegraphic messages, that seems to be genuine. Then here electronic message, 88A has been electronic message. Once electronic message has been forwarded, court may take a presumption as to the genuineness of the, not as to the originated, but as to the receiver. This person has received, to that extent this electronic message can be presumed. The presumption as to the electronic, the court may presume that an electronic message forwarded by the originator through the electronic mail server to the addressee to whom the message purports to have been addressed corresponds with the message as fed into the computer for the transmission. But the court shall not make any such a presumption as to the person by whom such a message was sent. The court shall not take any presumption as to the person by whom that message was sent, but it can take a presumption as to the person by whom it was received. So that is explained here in 88. Then comes the 89. 89, I said that under section 66 of the Evidence Act, you will produce a notice to produce a document before the court of law. You will not produce. So here the court shall take presumes that every document called for and not produced after the notice to produce was attested, stamped, executed in the manner required by the law. So here this has to be read conjointly along with section 66. Once the 66 notice had been given to produce a document, who is in the possession and authority of that power and authority of that document, he does not produce it before the court of law, then what is the ultimate effect of it? The effect will be landing in 89 of the Evidence Act. 89 says, presumption as to the due execution of the documents not produced, even after due notice given. The court shall presume that every document called for and not produced after the notice to produce was duly attested, stamped and executed in the manner required by the law. So this is how the presumption operates. After the section 66 to 89, you will have to compare and conjointly how to read it. Then presumption as to the documents of 30 years old. Whenever the document is 30 years old, the presumption as to the execution is presumed, that attestation is presumed. So you cannot go and search for the attesting witness after a period of 30 years, a flux of 30 years. Therefore, such a provision has been given. Same provision has been given for electronic records also, but the number of years have been restricted to 5 years. It is not 30 years that's been given. It has been restricted to 5 years, that is 90A. Presumptions to the electronic records of 5 years old. This is the pertaining to the electronic records. What it reads, where any electronic record purporting or proved to be 5 years old is produced from any custody which the court in the particular case considers proper, the court may presume, here it is may presume, that the digital signature which purports to be the digital signature which is proposed to be the digital signature of the person of any particular person and was so affixed by him or any person authorized by him on his behalf. So this is what the may presume, that the signature which is endorsed there in the document is duly electronically signed by the person whose name is figuring there. This is what the presumption under section 90A. So we go from here, from 79 to 90A, we have completed pertaining to the presumption, which is has to be connected with the section 4 of the Evidence Act. Still some more presumptions are at the back of this sections. Now after 90A, some of the presumptions are there. It's been given in section 113A, 113B, 114, 114A. 13A speaks of presumption as to the instigation of suicide. Then the 13B says presumption as to the dowry death. 114 is the general presumption as to the human conduct, natural event, public business and private business. And 114A is the absence of consent in the case of the rape. So these are the 4 or 5 presumptions which are coming down at the bottom. We will discuss at the time when we are reaching over there. Okay. Then we will come to the next chapter of this pertaining to the document. This chapter is chapter 6. This is chapter number 6 of the Evidence Act. That's exclusion of the oral evidence by the documentary evidence, in which the only documentary evidence alone can be given. No oral evidence can be given here. And so therefore this was the sections from 91 to 100. It clearly explains about the terms of the contract and oral agreement. Pertaining to the oral agreement, no evidence can be let in, and some of the ambiguous document, illegible documents, a document which can be applied, which can be application of the language of the document could be applied for the different set of facts. So what are all the effects of that? This is how this section 91 to section 100 speaks of. So first we will take this 91. Evidence of the terms of the contract. The terms of the contract which the law which requires the document to be reduced into writing. So if that is the mandate that's been provided by the law, that document shall be proved. That document shall be proved only by the document itself. So here you can recollect that section 62 of the Evidence Act as well as section 64 of the Evidence Act. 62 says that this document, even before 62, you can go to section 3 also, where the document, what is the document that's been described? Document that's been described is that any substance on any matter which is expressed or described by means of the letter figure marks. And further, if you come document, then what is documentary evidence? Documentary evidence is a document itself, it's produced before the court for its inspection. That's what the section 3 mandates. Then section 61 mandates the document could be proved by means of the primary evidence or secondary evidence. The document could be proved by means of the proof of the contents of the document is by means of the primary evidence or secondary evidence. And 64 mandates the document shall be proved only by the primary document except hereinafter exempted under section 65 of the Evidence Act. This is how the small framework about the documents. If you conjointly read this with the 91 here says, now I will read what is being stipulated here. When the terms of the contract or grant or any other disposition of the property have been reduced in the form of the document and in all the cases in which any matter is required by the law to be reduced in the form of document, no evidence shall be given in proof of the terms of the contract or grant or disposition of the property of any such matter except the document itself. This is a key word here which I have highlighted here, except the document itself. So only by the document you can prove the terms of the contract or prove the terms of the grant, or you can prove the disposition of the property. So the document is must and mandate and essential. You would have applied that in many of the trial cases, and in the appellate stage also you would have argued many matters pertaining to this section 91, which we very commonly apply. And section 92, if you go and take section 92 speaks of exclusion of the evidence of the oral agreement, exclusion of evidence of the oral agreement. And the terms of the contract, any contract, grant or disposition of the property or any other matter required by the law to be reduced in the form of the document have been proved according to the last section. The no evidence of any oral agreement or document shall be admitted as between the parties of such instrument or their representative in interest for the purpose of contradicting, varying or adding or subtracting any terms. So this is what this mandates. If the document is reduced in the form of the document, if it is reduced required by the law to be reduced as a document, then no evidence can be let in as to any oral agreement or any statement that oral agreement, oral evidence cannot be admitted at all. That's what here the exclusion of the oral agreement section 92 describes. I hope that it is clear. I think you have to read this along with the section 59 of the Evidence Act, which we can recollect that all facts can be proved by oral means, by oral evidence. All facts can be proved by oral evidence except the contents of the document. So here, all facts are by oral evidence permitted. Here, some of the oral agreement which had been made for beyond the contract which has been reduced into form of a document. So this oral evidence cannot be permitted or admitted to be an evidence here. That's what is explained here in 92. No evidence of any oral agreement or statement shall be admitted for the purpose of proving contracting, varying, adding or subtracting the form of its term. Here I have given some note. Compare it with the section 89 also, varying terms of contract. So if you see the 89, if you see the 89, the court shall presume every document called for. It's not 89, I think that it's a 99. You have to compare it with the 99. It's a varying terms of contract. We will go further. If you take 99, that is varying terms of contract, Varying terms of contract is something you can understand from the illustration. Just go through the illustrations which have been provided in all the sections, and it will make you to understand very clearly how to understand this section. See, a person who is not a party to the document, or is representative in interest may give evidence of the any facts tending to show the contemporaneous agreement of the varying terms of the contract. Contract is between the A and B. Here you see this example here. The contract is between the A and B, and says that I am giving you some cotton. A will pay the money on the delivery itself. That is what the agreement. Here B has to deliver the cotton. A will pay the amount immediately after the delivery. On delivery, it will be some money will be given. That's what is written in the contract. But subsequently, while delivering the cotton, A says, I need some about 3 months to settle the money. I don't have money at all. Now B says, agrees for it. Now this agreement, beyond the agreement of writing, this agreement is a oral agreement, understanding between the A and B that the money will be settled within a period of 3 months. So here, A and B are precluded from giving any evidence pertaining to this contract, oral contract, but assume that some money is due from the B to C. C is now suing now B for the purpose of returning the money, some money that is due from him. So now C can lead an evidence. This is a oral agreement between them that it said some 3 months time has been granted by the B for the purpose of A to settle the money. This C can lead an evidence, but A and B are precluded from leading an evidence, being a party to this agreement. So therefore here that has to be read along with this. That's why I given this varying terms of contract there. But the section has been wrongly mentioned. I'm sorry for that. Section is 99. Okay. Then now comes the exclusion. Similar exclusion is for to amend or an ambiguous document. Suppose a document has been ambiguous, so you want to apply it to the existing fact. The document says the language which was used in the document is of on its face is ambiguous or defective. Evidence may not be given. Here is also evidence may not be given. This is an exclusion. Evidence may not be given of the facts which would show that its meaning or supply its defect or curing the defect. This the wording is something different. Meaning or to cure the defect or giving a different meaning for that ambiguity. So suppose if I am agreed to sell a horse, this is an example, you see this example, agreeing to sell the horse for 1,000 rupees or 1,500 rupees. You cannot lead an evidence whether it is for the 1,000 or it is for the 1,500 rupees. This is a very simple explanation that's been given here in the illustration. When the document is ambiguous, you cannot lead any evidence at all. This is also excluded like that of the oral terms of the oral agreement. If you want to go to oral agreement 92, along with that you can read 99 also. So this is the exclusion pertaining to the ambiguous document. Then comes the 94, exclusion of the evidence against the application of the document to the existing set of facts. Suppose the document says a set of one meaning, but when you apply it to the existing fact, but it does not suit but it's not fitting with the existing fact. So therefore, to that extent, you can lead evidence. Here the evidence is permitted, whereas in 92, 93 and 92, you are completely excluded from giving the evidence. Therefore, the marginal heading itself has been termed as the exclusion of the evidence. Here, we will see the 94 here. The language is used in the document is plain in itself, and when it is applied accurately to the existing facts, evidence may not be given to show that it was not meant to apply to those facts. Here, A sells to B by deed my estate at Rampur containing about 100 acres, 100 bighas, something like that. A has an estate at Rampur containing 100 bighas. Then the evidence may not be given as to the fact that I did not mean to sell this estate. So here it's been agreed upon. Here the application, you are applying the terms of the document against the existing fact. That's it. You are applying the document. What is stipulated in the document is plain in its meaning. So you wanted to sell this property at Rampur, which the extent is 100 bighas or 100 acres. Exactly, that is what. You cannot now turn around and say, no, I did not mean that one. I wanted to sell something else, but it has been termed as the Rampur property, and the extent is 100 acres. This is now, you are now precluded from leading an evidence pertaining to that. The language is plain in itself when it applies accurately to the existing fact. Evidence may not be given to show. This is also exclusion. 94 is also exclusion. 92 is exclusion. 93 is also exclusion. And 94 is also exclusion of the document. So now we are coming to the 95. We are now coming to the 95. So evidence as to the document unmeaning to the existing facts. Suppose if it does not fit with the terms of the contract is something different, and it is unmeaning, and it does not have any meaning to the real facts of the case. It's not fitting to the real existing fact. So in that instance, whether the evidence could be led or not, that's what is defined in the section 95. The language used, when the language used in the document is plain, that's 95. It's unmeaning to the is plain. It's also plain in itself, unmeaning to the existing facts. The evidence may be given to show that it was used in the particular sense. Evidence may be given here. There is no bar at all. Evidence may be given that it is written in particular sense. A wants to sell a B at Calcutta, and he does not have a house at Calcutta, but he is having a house at Howrah. That Howrah and Calcutta is separated by about 15-20 kilometers. That's it. Calcutta means Calcutta includes Howrah also. So therefore, if you say that it's in whether you mean in the document that it's in house at Calcutta, or you mean in the document whether it's house at Howrah, does not no meaning at all. No, doesn't make any difference at all. But both the houses are same. Here, evidence may be given to show what is the difference between the 94 and 95. In the 94, you are precluded from giving evidence. Same thing that of 93 and 92. And here 95, you are not precluded. You can lead evidence as to the unmeaning or though no purpose in no difference. No purpose is going to be solved because of this difference. Both mean the same, because the house at Howrah and house at Calcutta both are same. It's almost similar. We can also say simple example like that. Suppose house at Chennai. That similarly, if you say that house at Pallavaram, so Pallavaram may come to Kanjipuram district. So it doesn't make any difference at all. If such ambiguity or some mistake or defect in the document, that document could be that could be applied easily, and the evidence could be led pertaining to what is really what they meant. That's what is 95 says. Okay. Then 96. Evidence as to here, it's the stipulation of the language in the section will be something might be hard to understand. But if you go to the illustration will make you to understand very simply what the section means. So therefore, my advice would be that better you read illustration first, then you go and understand the section what is stipulated. So I am giving a simple narration. If you read the sections 2 or 3 times, you will come to understand what are the documentary values of it and evidentiary values of the document, what are all the areas in which the exclusion will be in operation, and what are all the areas in which you can lead evidence that is in operation. So exclusion in operation one part, and you are permitted to do it in lead evidence is another part. This is what the 2 parts that's been here stipulated. Nothing hard to understand, very easy to understand. Go ahead with the illustrations. Okay, evidence as to application of the language which can apply to only one of the several set of persons, several set of things. You can take it as a things instead of person. Person is written here in the marginal note. You can take it as a things. When the facts are such that the language used might have been mean to apply to any one or could not have been mean to apply to more than one of the several person or things, evidence may be given of the facts which show which of those persons or things it intended to apply. Evidence may be given to those facts to whom it is intended to be applied. Intended to apply. This is what A agrees to sell B rupees 100 for rupees 1000 of my white horse. There are two horses. My whole white horse, that's what the A says. One of my white horse will be sold. But evidence can be led because the document and agreement can apply to horse A and horse B also. But both the horse A and B both are white. So this evidence can be permitted to lead in pertaining to which horse he mean to sell. So this is what the 96 says. 96 says it's not exclusion. It is a permissible evidence. Evidence can be let in for the purpose of showing that the language of the document applies to which several set of things which is there in the real existence. This is what the 96 says, and 97 is similar to that. And in case application of language to one or two set of facts to which neither of which the wholly or correctly the language applies. Here, when the language here, you go to this illustration. We will go to illustration. Then we will come to the section. Okay. A agrees to sell B my land at X, my land in Chennai, in the occupation of one Ramasamy. Land in Chennai in the occupation of Ramasamy. Here, A has a land in Chennai. A has a land in Chennai, but is not in occupation of Ramasamy. But A has a land at somewhere in Madurai, which is in occupation of Ramasamy. So see the difference. You just read the illustration. A agrees to sell B my land at X at Chennai in the occupation of Y. A has a land at X at Chennai, but not in the occupation of Y. But he has a land in occupation of Y, but it is not in Chennai. He has a land in occupation of Ramasamy, but that is not in Chennai, but that's in Madurai. Then the evidence may be given as to showing what it means to sell, what they mean to sell. A mean to sell. A mean to sell which property, whether it's a property at Chennai or it's a property at Madurai. It's from the illustration. If you now go to the real stipulation of the words in the section, then you will be able to understand what the section means. It's very hard and dry subject. It's very hard to understand. Even the application also the application of these sections also will have a lot of struggles in the court. But we hardly apply these sections in the court. That's what I feel like. I also never applied. I read and understood all those things. Please understand this 97. When the language use applies partly to one set of existing fact and partly to another set of existing fact, but the whole of it does not apply correctly. Whole of it means this existing set of the what is the terms will not apply to any of the existing facts correctly to either. Evidence may be given to show to which of the two it mean to apply. Whether it is a property at Chennai, or whether you can say whether it's a property which is not possession of Ramasamy, or it is not in the possession of Ramasamy. We can take it that. If it is not in the possession of Ramasamy, that's in Chennai. If it is in the possession of Mr. Ramasamy, then that is in Madurai. This is how it has to be read. These are the ambiguity. These are the things which will come because of the difference in the terms of document and the existing set of facts. So here the 97 is defined here like this. 98 is illegible character. Some illegible character which could not be understood, which are not uncommonly intelligible. That is commonly intelligible. Uncommonly intelligible characters are used in the document. So to that extent we can lead evidence. These are the permissible areas where we can lead evidence. So from 95 onwards we can lead evidence. 92, 93, 94. All the three are exclusion of evidences. 95, 96, 97, 98 are the things on the area on which we can lead evidence. This is coming under the chapter exclusion of the oral evidence by the document evidence, in which the document alone will speak and the oral evidence is completely excluded. You have to understand this, the practical application of this, and this section is in consonance with the section 50. This entire chapter is in consonance with the section 59 of the Evidence Act. 59 says all facts can be proved by the oral evidence except the contents of the document. So if you come to the contents of the documents, then the contents of the documents could be proved only by these means, like 91 to 99, and 100 is a section which is 99, which I already explained, varying documents, that is A and B cannot give an evidence. It is also exclusion here. But C can give evidence. But C is a person who is an interested party. Go to the illustration and read it, and then you can understand the real provisions of this 99. And section 100 is a thing that this chapter is not applicable to the Indian Succession Act, which is need not have to go into deep into that. Then we'll have to go to the burden of proof. I hope that from here up to section 100, from 3 to 100, we have covered almost what is oral evidence and documentary evidence, relevant fact, electronic evidence, and the presumption as to various kinds of documents we have, and proof of the documents, and the signature, comparing the signature, power of the court to compare the signature under section 73, and the 67 is proof of how the proof of the signatures, seal and handwriting are proved, and 47 has to be compared along with that. Conjointly it has to be compared, means it has to be conjointly, it has to be read, and 47 is the expert opinion on the signature, handwriting and seal. Similarly, 67 is how it is to be proved, and 673 is the judge's power to prove it. All these things are covered here between this section 3 to section 100. Now we will go to the burden of proof. For burden of proof, you have a case called Surjit Biswas. Say case by name Surjit Biswas. Just type it in the India Kanun or in the Google Surjit Biswas and India Kanun, where you will come to know about that. What is a proof of what is a burden lies, and proof beyond reasonable doubt. All these things are clearly defined and well discussed in that judgment. And 101 is from 101 to 110, I think. It goes with the burden of proof, to whom the burden lies, and whether the burden shifts, and ownerships and burden shifts. Burden is a larger concept where it will be on the head of the person, which will be on the head of the person who requires a court, who desires a court to believe that such fact exists. This always on the person who requires a court to deliver a judgment on existence of the particular fact. Again, you go to the section 3 of the Evidence Act, existence and non-existence of the fact. And if you want the court to believe on the basis of the existence of the fact, believe the existence of fact and deliver the judgment, the burden is on me. Whoever goes to the court, the burden. That's what the first 101, 102 and 103, all the three sections, up to 104. All the four sections defines that a person who really approaches a court has to prove that what is that the proof, the fact on basis of which he asserts its right and liability. So this burden always lies on the person who is first approaching the court. The exemption would be 105 and 106. 105 says if you are relying upon one of the exemptions provided in any of the act or statute, then the burden onus will shift to the 105, or to the other side, that is to the accused. Suppose if you are committing a murder and you are claiming that I am falling under the exemption of private defense, self-defense. So for the purpose of self-defense I committed a murder. So then certainly your section 96 of the Indian Penal Code and section 100 of the Indian Penal Code will apply, and you will be entitled for, you have to prove that you have done it on the basis of, for the purpose of my self-defense. Once you rely upon this exemption, then the burden will shift on you under section 105 of the Evidence Act. You have to prove before the court that there was a grave danger to my life, and therefore for the purpose of self-defense I will have to protect myself, and I was forced to attack, or I was constrained to attack to defend myself, my property or my body. So this is 105. 106 is the burden. It's a onus which, once the burden has been discharged by the prosecution, that initial burden will be discharged. I'm just giving an outline only. We will go well into the section 101 and 102, 103 again. I'm just giving the outline. For the 106, once the primary burden has been discharged by the prosecution, then the onus will be shifting to the accused under section 106. If in the case of the kidnapping, the prosecution only will show at one point of time the deceased person or the kidnapped person was in the custody of the accused. They will prove only to that extent. So there will be a missing link. That's the fact which is within the, especially within the knowledge of the accused. Suppose if this fact is missing, that missing link has to be given by the accused. Accused has to say how the deceased have died. So therefore here the burden will shift. If he does not discharge his onus, the burden will be on the prosecution primarily to prove that the deceased was in the custody of the accused. And then later on, how he died and how the death was caused. Then the burden will be upon the accused to explain it, and under section 106. If he does not explain, then the presumption will be invoked under section 114 of the Evidence Act. This is the beauty. It's one by one. Every section is linked to another section. Therefore, you have to take it as a framework and scheme, as a whole scheme you have to see, and you have to analyze the issues and to be adjudicated. So we will come to section 101 now. So here what it reads, please see. Whoever desires any court to give judgment as to the legal right or liability dependent on the existence of the fact which he asserts must prove those facts exist. He must prove those facts. Whoever desires a court to give a judgment, court has to give the judgment. I desire the court to give the judgment on the basis of any legal right and liability dependent on the existence of this legal right is dependent on the existence of the particular fact, and he asserts that particular facts, and he must prove, if he asserts that particular fact, he must prove that this fact exists. Suppose if a property is mine, somebody is disturbing my property. I say that this property was purchased from 1 year. My right is asserted here. I go to the court to give a judgment that I am the declaration that I am the title owner of the property. So I desire the court, once I desire the court, give me the judgment on the basis of the existing fact, on the basis of this document, I am the title holder. I will have to go and prove. The burden is on me to prove before the court. This is what the section 101 of the. There are some illustrations which have been given, very easy to understand. You can go through that. Second one is the burden on whose. If somebody fails, here the burden of proof in the suit or proceedings lies on the person who would fail if no evidence is given by either side. If assume that second analogy to it's an extension to the 101, you can say that if you are going to the court, the burden is that you are not giving any evidence. I am just simply keeping quiet. Give me the judgment. This is a prayer. That's it. I am the title owner of the property. I fail to give any evidence. Other side also failed to give any evidence. What the court will do? Simply it will grant or not grant. So since I failed to give anything else, if I fail to give anything else, I will be the loser. So therefore the burden is upon me to show that this property belongs to me, and these are the evidences for the purpose, and these are the evidences on which the issues are to be adjudicated, and I have to lead the evidence. So the burden lies on me. So on the person who would fail if no evidence is given by either side. This is what the section 2. Then section 3, if you come, there are some illustrations which are very simple, you can understand. Then section 3, 103, burden of proof as to particular fact. The burden of proof as to any particular fact lies on the person who wishes the court to believe his existence. It's also similar to the 101 and 101. It's an extension to the 101, you can say. I desire the court to give the judgment on the basis of existence. What is the word language that's used here? I desire the court here. Desire any court to give a judgment on the basis of the existence of any facts in issue or relevant fact, any faction issue, any fact, on the basis of which the right and liability rest. Here, 103, I wishes the court, instead of desire there, here wishes the court to believe the existence unless it is provided by any law, or I will not go to this. Who wishes the court to believe. So, and the burden will be on the person who wishes the court to believe. So, it's also similar to the other 101. We can go through the illustrations also. And then I will skip to the 104. Here it's little different from 101, 102, 103. It's little different, not much. So the burden of proving a fact to be proved, to make the evidence admissible, to make an evidence admissible. What is it simply saying? The burden of proving any fact necessary to be proved in order to enable any person to give any evidence on any fact is on the person who wishes to give such evidence. So again I will read it for better understanding. I will read it. The burden of proving any fact necessary to be proved. Burden of proving any fact which is necessary to be proved in order to enable any person to give any evidence of any other fact is on the person who wishes to give such evidence. You have to read it again and again for the purpose of understanding. Simple analogy I will tell you. There is a dying declaration which is admissible under section 32 of the Evidence Act. This dying declaration has to be made admissible. Before that dying declaration has been made admissible, you have to prove the court that the person has died. So unless otherwise you prove the fundamental fact that the person is died, so you cannot make that dying declaration admissible. This is what the example, best example is. This example is given here also. A wishes to prove a dying declaration by B. He must prove the B's death first. Here is the first illustration. So this is what is rounded here in this section. Section is little difficult to understand, but before that you go to the illustration and read it, and then you can divide the section into different segments and you can understand the section. The burden of proving any fact necessary to be proved. What is the burden of proving any fact necessary to prove? Dying declaration. In order to enable any person to give any evidence of the other fact is on the person who wishes to give such evidence. This is what the explanation is. So if you want the dying declaration to be admissible, you have to give evidence and prove before the court that the person who gave the dying declaration is dead first. He died, and before dying he gave the dying declaration. So the death has to be proved first. B's death has to be proved first. Then the dying declaration can be proved. But the marginal heading will be very clear. Burden of proving a fact to be proved. What is the proved? To make the evidence available. Make the evidence available is 32. Under section 32, dying declarations are evidence to be available. What is the fact to be proved? Fact to be proved is the person who gave the dying declaration has died. That fact has to be first proved. Then the dying declaration has to be secondly it has to be proved. That's what the 104 says. Then 105 I discussed. It's a exemption when the person is excused of any offence, right of private defence, falling under section general exemption of the Indian Penal Code. The burden of proving the existence of circumstances bringing the case within any of the general exemptions in the Penal Code or within any special exemptions are provided or proviso contained in any other part of the same code or in any law defining the offence is upon him, and the court shall presume the absence of such circumstances. Okay, for this 105 you read a case called Jeremy. It's a Mangadu police station. A case called Jeremy. That's called. Yesterday I have noted down the case. It's a Jeremy Mangadu police station. It's written by Honorable Justice Nagamuthu. It's a case different. I'll just give you the small facts of the case. The case of father making an attempt to rape the daughter. Daughter takes a knife, repeatedly reprimands, don't do that, please don't do that. But father, he was in inebriated mood and he was in the mood of raping his own daughter. The daughter took the knife and stabbed 3 times. Stabbing was given to the father. Daughter stabbed father 3 times. On the spot, the daughter expired. Ultimately, one inspector of police by name, his name is Alagu. I read the judgment yesterday only. His name is Alagu. He ultimately came to the conclusion that it was completely done on the basis of the private defence. Yet he filed the charge sheet. She was arrested. She was kept in the custody for about she was in the jail for about 40 days before granting bail. And the charge sheet has been filed. but charge sheet has been filed on the lesser offence, that is not under 302 for committing murder of the father. I say that it is a 304. He filed it a culpable homicide not amounting to murder, saying that it's falling under the one of the exemption, right of private defence. On the basis of the right of private defence, it's falling under the one of the 5 exemptions in the section 300 of the Indian Penal Code. Therefore, it will fall under the 304. So that's what the charge sheet that's been filed. That girl, Miss Jeremy, she was a second year student of BSc Computer Science in some Joseph College somewhere else. She goes for a criminal OP for the purpose of quashing it. He narrates all the facts and circumstances, and notice was issued to the other side. State also appeared. They said it's a case of it's a private defense. Ultimately, the case was quashed, saying that Gandhi's principle and quoting other principles, saying that it's a right of private defense when the modesty is going to be affected. When I'm going to be raped by the father, what would be the course of protection that would be available for the daughter? And doctor, without having any other option, took the knife and stabbed the father to save her modesty. This is what the ultimate case, that ultimately it has been quashed. And on the basis of this, I was also told that on the basis of this case, another case this case has been quashed. And there is a passing remarks in the judgment in the last paragraph. If the investigation officer had been given proper advice, he would have referred the matter, he would have filed a referred charge sheet for the purpose of closing the case. And also, it is not required that girl has to be arrested. Taking into consideration the Joginder Kumar's case, that the arrest is not mandate in all the matters, all the cases, unless otherwise is a habitual offender, threat to the society, or if the accused is going to be let off in the bail, if he is going to be not arrested, he will commit some other mistake, so some other offence. All these things have to be taken into consideration before arrest. Arrest is not mandate in all the cases. It's a passing remark in the last page, which make anybody else to shed tears, that if the investigation officer would have been advised, she would not have been arrested, she would not have been detained in the prison for about 40 days, and she would not have faced the ordeal of the trial that she faced because of the charge sheet. So this is with this remarks. Finally, the case was quashed. On the basis of this case, another IPS officer at the Supanda Police at Madurai, he closed another case of the similar nature, where the father attempted to rape the the daughter, and that is also referred, and the case has been closed, and on the basis of this criminal OP. This Jeremy versus State of Tamil Nadu. You can read it from the India Qanun. It's available there. It's about 2012 judgment, I think. Okay, this example which I can give for this 105. That's these exemptions which are falling under certain categories. The burden shifts to the accused to show that I am falling under the general exemptions. I am not committing an offence. This is what this 105. Then for 106, this is a fact which is especially within the knowledge of any person. The burden of proving the fact is upon that person. The best example for this section is, if you read the Saravana Rajagopal's case, that's been where one lady by name Jiva Jyoti, her husband has been kidnapped and has been done to death, I think. That incident of custody being transferred to A4 or A3 to A6 at Tirunelveli, at the road leading to, it's a junction which is leading to some Kodaikanal. To that extent, PW1 and PW2, the lady as well as the mother of that lady both will say that the custody of the deceased was transferred from the accused number 1 to accused number 3 to 6. They took them in a car in a road leading to Kodaikanal, and somewhere in Kodaikanal the body was found. The person, other belongings were picked up by the local police there, and other dresses were also picked up, and this is how the body was identified, and ultimately it was proved that this is a man who was kidnapped, has been killed. So how he has been killed, now the burden is on the A3 to A6. This 106 has been very much applied there in this case. And this is how the burden shifts. Once the initial burden has been discharged, that the custody of the deceased was transferred from the accused number 1 to accused number 3 to 6, and accused number 3 to 6 took the deceased in a separate car, and this car was returning from Tirunelveli to Chennai. One car was going from Tirunelveli to Kodaikanal, and this to that level the burden has been discharged with the prosecution. There is a missing link how the deceased have died. That missing link is especially within the knowledge of the A2 to A6, which was applied there. 106 was applied there, and I think it's Justice Mishra judgment in High Court. A very well written, very detailed judgment that was written. Very well discussed judgment that is. Please go through the judgment for the purpose of understanding this 106. That apart, I can also give you some other judgment for the purpose of this 106. One Satyanarayanan, it's a Supreme Court judgment. Satyanarayanan, Kasi Ram, and Mir Mohammed Omar. Mir Mohammed Omar. These are the three cases where you can understand this 106. Once again I will tell you. One is Satyanarayanan. Second one is Mir Mohammed Omar, O-M-A-R, Omar. And the another one is Kasi Ram. Apart from that, please go through this Rajagopal's case also. Saravana-Bhavan's owner. These are the 3-4 cases. Please go through that for the purpose of understanding this 106 of the Evidence Act. Then comes the 107. The burden of proving the death of the person who had been alive within the 30 years. A person is alive within 30 years. Then the burden of proving that the person has died is upon the person who affirms it. Here, please go through the word here. The question is whether a man is alive or dead, and it is shown that he was alive within a period of 30 years. The burden of proving that he is dead on the person who affirms it. This is how the section 107 describes. Then similarly, parallel to that, 107 also similar to the, but here the proving death, here it is proving the person is alive who is not been heard of about 7 years. That's it. Here the question is whether the man is alive or dead, and it is proved that he has not been heard for about 7 years by those who would have heard of him if he had been alive. The burden of proving that he is alive is the person who affirms it. He is alive affirms it. There, first 106 and 107 parallelly goes together. There it is burden of proving the person is dead. Here the burden of proving that the person is alive. There it is 30 years. Here it is 7 years. Very easy to understand. You can go through that and read it. And this similarly, it is a burden of proving the relationship. 109. Burden of proving relationship and burden of proving the ownership is the 110. If a relationship is existing like that of the partners, or it's like a tenant and owner, or it's a principal and agent, and it ceased to exist, the person who affirms that it ceased to exist, they have to prove before the court of law. The burden is on them to say that it is ceased to exist. I am no more a partner in the firm, and therefore I don't have any liability, or so and so, whatever it is, whatever the claim he is making. This is 109. Like that, ownership. If I am in the possession of the particular property, and it could be presumed I am the owner of the property. If a contrary is said by somebody else, the burden will shift on the person who says the contrary. That's what has been explained here in 110. Please go through that. When the question is whether any person is owner of anything of which he is shown to be in possession. I am in possession of the property, of my own property. The burden of proving that he is not the owner is on the person who affirms that he is not the owner. Those who affirm that he is not the owner of the property, he has to prove before the court of law that he is not a owner. So therefore, the burden not lies on the person who is really owns and he is in who possesses the property. So he shifts to the other side, who is saying the contrary view to that ownership. So here this one. The most important thing is now here, section 111, certainly you can expect some question pertaining to this 111. See, the proof of good faith in the transaction where one party is in relation to the active confidence of the another. Here, first you go to the illustration, then you come to the section. Go to the illustration. I am the advocate. One of my clients, I am dealing with so many clients. I am buying a property from one of the clients. Then subsequently the client goes and seeks for the declaration. The sale is null and void, as because he has influenced his dominant position. I was in the receptive side, and therefore I was forced to sell the property to him. Then the burden will be on the attorney or the advocate to say that the purchase was made on the basis of the good faith. This is what is explained here in this section. The burden of good faith is in a transaction where one party is in active confidence of the another, where there is a question as to the good faith of the transaction between the parties, one of whom stands to the another in a position of the active confidence. The burden of proving the good faith of the transaction is on the party who is in the position of the active confidence. So here the illustration, if you go, good faith, the sale by a client, the good faith of the sale by a client to the attorney is in question in a suit or proceedings brought by the client. The burden of proving the good faith of the transaction is on the attorney. So this is a section pertaining to the advocate. Please go through that 111 and see the illustration also. Likewise, father and son. Second illustration given is a father and son. So son sells the property to the father and files a suit against the father that the property has been obtained by means of the coercion or some other method, by means of the undue influence. So here also the good faith, the transaction is of the good faith is upon the burden of good faith, proving the good faith, the transaction is of good faith is upon the father. So here the second illustration which says, then certain offences, presumption as to certain offences pertaining to this waging war or collecting weapons to wage war against India, all this 121, 122, 121A and all, which I don't think that is much importance. Birth during marriage, that conclusive proof which we have already discussed about that, and proof of cessation of said territory which is not required. I don't think that is so important. Then we come to the 113A, presumption as to the abatement of the suicide of the married woman. When the question is whether the commission of the suicide by the married woman had been abetted by her husband or any relative of her husband, and it is shown that she has committed suicide within the period of 7 years from the date of her marriage, that her husband or such a relative or husband had subjected to cruelty, court may presume, having regard to the other circumstances of the case, that the suicide has been abetted by her husband or by her relatives of the husband. Here, marriage should have been done within a period of span of 7 years, and she should have committed suicide, and there is an abatement could be presumed, and she had been subjected for cruelty for the purpose of she had been subjected to cruelty, then therefore she committed the suicide. So to that extent the presumption could be raised. This presumption is a rebuttal presumption. This presumption against the husband and the relatives of the husband could be rebutted that it is not an abated suicide, maybe because of some other depression or some other reasons. So this is what the 113A says. Parallelly, if you go to 113B, there is a presumption as to the dowry death. The question is whether a person has committed a dowry death of a woman, and it is shown that soon before her death, such woman has been subjected to cruelty or harassment by the husband. In connection with the demand of dowry, the court shall presume such a person has caused the dowry death. So here, this has to be read along with the 304B of Indian Evidence Act, I think 304B, which deals with the dowry death. The presumption is that when there is a demand soon before the death, the demand should have been done soon before the death, and the woman has been subjected to cruelty for the basis for meeting out the demand. As because the demand has not been met out, she has been subjected to cruelty and harassment. if that is the case, if this demand has been proved soon before the death, then the court can invoke the presumption under section 113B that the death has been caused due to the dowry demand, and the person who has inflicted this cruelty and harassment is liable for the causing the dowry death. This is what the 113B which stipulates. So then comes the 114, which is seems to be a very important section, which the tool which is given, very powerful tool which is given to the court for presuming the presuming a fact on the basis of the natural events, and on the basis of the human contact, on the basis of the private business, on the basis of the public business and all. Court may presume the existence of any fact which it thinks likely to have happened, having regard to the common course of natural event, human contact, public and private business in their relations to the facts and circumstances of the case. This is what the section says. So on the basis of the human contact, if you see that one murder that has happened in Nungambakam railway station, Swati's murder's case, and when the clue was that one fellow will be running, a CCTV camera footage will be recovered by the police, where the fellow will be Ramkumar, I think that his name is Ramkumar. He will be running very fast, but for no reason. That the incident would have happened by about 7 o'clock, and 2 or 7, within 2 or 3 minutes, the camera shoots that the fellow is running. So that gave a clue ultimately what's his contact. This is a contact on the basis of which the court can take a presumption. It's ultimately this is a basis for the human contact. The presumption on the basis of the human contact would be invoked by the court under this 114 of the Evidence Act. A very powerful section that has been given on the proof of the one fact would be presumed on basis of some contact, previous contact and subsequent contact. It could be presumed, and on the basis of the natural contact, court can presume that the contact is in consonance with the guilt or with consonance with the innocence, and also in consonance with the guilt or in consonance with the innocence. If it is consonance with the guilt, it will land up in conviction. If it is in consonance with the guilt, you will land up in the acquittal, or it will be in consonance with the innocence. So this is how we can frame it in 4 different categories: consonance with the guilt, consonance with the innocent, in consonance with the guilt, in consonance with the innocence. Also, you can presume all these 4 important things. You can 114 gives a very, 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 very powerful tool for the court to presume a fact on the basis of the human contact, private business or public business, banking transactions, natural course of common course. Suppose a man says that in the morning sun was rising from the west. Natural event it is. Court can presume that what he is saying is wrong. The presumption would be otherwise. Sun can come only from the eastern side. This is what the presumption. This is a power which is given. If you go through this illustrations, very beautiful illustration. The 8-9 illustrations are given here, and every illustration is important, I will say. And just go through the illustrations. Man is in possession of the stolen goods. Immediately after the theft, the prosecution proves that there is a theft, and these were the properties that's been stolen. And immediately after the theft has happened, these properties were in the possession of the accused. Then what could be the presumption? Presumption is, if a person is in possession of the stolen goods immediately after the theft, is either he has committed the theft or he has received the goods knowing that it has been stolen, unless otherwise the contrary is proved. Can account for his possession. Unless otherwise he can account for his possession. So if the initial burden has been discharged by the prosecution under section 101, 102, 103, 104, initial burden has been discharged, then the burden, onus will shift. The burden will be in the part of the prosecution. The onus shift to the accused to say that, I can say that somebody has given to me, I took it from the road, it was lying on the roadside, I found a bag, I do not know from whom it came here, by whom it was thrown or kept there. I just opened it, I found it. Or I bought it without knowing it is a stolen property. Some explanation could be given. he has to account for it under the illustration number A. If the account given by the accused is plausible and if it is accepted by the court, then it is rebutted. That presumption is rebutted. The presumption is rebutted, and the liability under the offence is vanished, goes or evaporates. And if the presumption is not rebutted, or the explanation which is given to the court is not accepted, then the presumption will stand on the basis of which the court can go ahead for the conviction of the accused. This is what has been explained here in simple explanation has been given, illustration given here. Next one is that if the accomplice is unworthy of credit, if the court presumes that the accomplice is unworthy of credit, unless he is corroborated in material particulars. Corroboration is used here. We already discussed in the first part what is substantive evidence and what is corroborative piece of evidence, which we already discussed there in the first part. Here the accomplice is unworthy of credit. If you see this illustration B here in 114, you can simply, if you reconcile it with section 133 of Evidence Act, which says that nothing is unlawful in convicting the accused on the basis of uncorroborated testimony of the accomplice. The wording will be different. We will go in the subsequent section. We will discuss about that. If you take that 133, the wording is that this is not unlawful to convict a person who is accused of alleged to have committed an offence on the basis of uncorroborated testimony of the accomplice. There, uncorroborated testimony, on the basis of uncorroborated testimony of the accomplice, you can convict. That is legal. That's what is said. Simply saying. Here it says, accomplice is unworthy of credit unless he is corroborated in material particulars. There seems to be some light disturbing terms will be there. But here, if the court presumes that he is unworthy, the court does not presume that he is unworthy, but if the accomplice evidence is worthy of confidence, worthy of credit, trustworthy, inspires the confidence of the court, then he can go ahead for the conviction without seeking for any corroboration. But if the court presumes that the accomplice is unworthy of credit, some doubt is there in his version, so then it has to be correct. Still that accomplice evidence is a substantive case, but he is to be corroborated by material particular. That's it. He is to be corroborated from the material particulars from some other independent source. But that accomplice will not become a corroborative piece of evidence. Accomplice is still a substantive piece of evidence, but doesn't inspire the confidence of the court. To get the confidence, to get the weightage and sufficiency to convict, the corroboration is required from the material particulars to corroborate the evidence of the accomplice. That's what has been defined here. If the court presumes that accomplice is unworthy of credit, then it is corroborated unless he is corroborated in the material. If he is corroborated by the material particulars, he is worthy of credit. That's what is defined here. Okay. Then in the bill of exchange is accepted and endorsed. It was accepted and endorsed for the good consideration. That's it's a purely a civil nature. Then comes the things are state of things shown to have in existence within the period which is shorter than that could exist. Then it's like a river that's going on. 5 years the river was there. There was a frequent flood, and the river can vanish. Still, you can presume that there was an existence of the river in that course. That's what the explanation and the explanation that's been given. And next one is very important. E. All presumption, the court can presume that judicial and official acts are being performed regularly in their due course. That's what the private business and public business which we have discussed there. If a judicial act and official act have been regularly performed, we can presume that it is regularly performed. There was one case where I dealt with very recently in the Supreme Court. There was an injury in the back of the deceased, which was unnoticed by the postmortem doctor. That injury was found in the inquest report, but it was not noted in the autopsy report. When we took a plea of this gives a doubt about this incident when we raised the plea, then the court said that the official act, you have not contradicted with the doctor that did you turn around that body or turn over the body to see whether there is a back injury. No cross-examination pertaining to the point. Nothing was elucidated. Doctor has to say that I turned but I did not see an injury. It was also not said. But there was an injury at the back which is noted down in the inquest report. We said that there is an injury in the inquest report which was not declared by the doctor, noted by the doctor, or it's nothing had been stated by the doctor. Therefore, it's a material particular defect in the material particular. Ultimately, court said we can presume that official act as well as the judicial act are regularly performed. Court can presume it. Therefore, you cannot raise that plea at all. Simply, we were close. Our argument were shut down. Then common course of business. Where it's a common course of business, what is happening in the bank and other things and all. The evidence which could be given but not produced, then the adverse inference. From here, the adverse inference can be raised. Evidence could be given from G. If you take the G, illustration G, if you take, evidence could be given, evidence which could be and is not produced would, if produced, be unfavorable to the person who is withholding it. So here we can take an adverse inference. You can also connect this with section 66 and also subsequently I said section 89. 89, if the document not produced, we can have a presumption. The illustration says that document, if it is not produced, it was duly executed, attested, and it was executed and attested. Section 89 you recollect, then it could be read along with that, conjointly it could be read. The evidence which could be produced but not produced, if produced, should be unfavorable to the person who is withholding it. To that extent, the presumption, adverse inference could be drawn. Similarly, the man refuses to answer any question which he is not compelled to answer by law, then the answer, if given, would be unfavorable to him. This is also adverse inference, pertaining to the adverse inference. And then the last one is pertaining to the obligation, that is pertaining to some promissory note or something like that. If the obligor is having the document, I have to pay somehow rupees 30,000 to somebody else. That promissory note I executed is in my hand. Then the presumption could be raised that I have discharged my obligation. So therefore the promissory note has come to my hand. Otherwise it will be in the person to whom it was, in whose favor it was executed, from whom the money was borrowed. So this is what the 7, I think that's about 8 or 9 illustrations are there. Please kindly go through that. It will give a clear picture about the power of the court under section 114 of the Evidence Act. It's a very interesting area which could be read over. 114. Then the presumption as to 114A is a presumption as to absence of consent in the case of rape. This is 114A. This also could be easily understood. Nothing special. Then estoppel. Estoppel is nothing but making a person to believe a particular thing and making him to act upon it. Ultimately, they say that ultimately I withdraw from it and I am also estopped from that earlier conduct, estopped from denying the earlier conduct, that I made him to believe and made him to act upon it. Here in the illustration, if you see, A intentionally and falsely leads B to believe that certain land belongs to A. I made him to purchase, I am the A here, I made him to purchase a land by the B. By the time I sell the land to the B, I did not have the title. This land was not with me and did not have the title, but I made the B to purchase it. Ultimately, it says that I am precluded from saying that I did not have title at all at that point of time. Here you see that the land thereafter becomes a property of A, mine. A seeks to set aside the sale on the ground that at the time of the sale he had no title. He must not be allowed to prove his want of title. So he must not be allowed to prove the want of title at the time of the sale. I am estopped from doing so. Similarly, estoppel on tenant and estoppel on bill of exchange. You can go through and understand. Then comes the important area. It's called witnesses. It's the most important area. Witnesses and examination of the witnesses. Chapter 9 and Chapter 10 of the Evidence Act. Here, the witnesses We'll start from section 118, who may testify, that is a competency of the witnesses. Who are all the persons who are competent to make depositions before the court of law. That's what the 118 says. It simply says first all the persons are competent unless prevented from understanding the question and giving the rational answer. That's it. You have to understand the question and you have to give rational answer for that. If these two conditions are satisfied, then you are a competent witness. That's what 118 says. The unless says the qualifying conditions, that unless you are prevented from understanding the question put to you and giving rational answers to those questions. If you are not able to understand the question, if you are not able to give rational answers to the question, by the reason of your tender age, by the reason of your extreme old age, by the reason of your body or mind or body disease, then you are precluded from giving evidence. So these are the two mandates that's been given. All the persons are competent witnesses. Here comes the child witness, whether it is a competent witness or not. If you recollect the first discussion which we had in the part 1, we compared it with some of the provisions had been compared with the Oath Acts. On the Oath Act, on the basis of the Oath Act, what Oath Act mandates is that if you take that Oath Act, for the purpose of this, I'll take you to some other chart and I'll revert back to you here, and just bear with me for some time. If you can see this comparative chart which I have given, section 8 of the Oath Act, which states that every person giving evidence on any subject before the court shall bound to state the truth. There is a mandate that's been fixed here, that he shall bound to state the truth before the court of law. That is section 8 of the Oaths Act. Section 7 of the Oaths Act says, if there is an irregularity or there is an omission in administering the oath, if there is an irregularity or if there is an omission in the administration of the oath, that will not render the evidence inadmissible, or it will not also affect the proceedings also. It will not invalidate the proceedings, or it will not affect the it shall not invalidate any proceedings or render inadmissible the evidence which had been given. It's only pertaining to the credibility. It's going to the credibility. It is not pertaining to the admissibility. You can admit very well the evidence that's been given without the oath is admissible. Section 7 mandates here. Section 7 mandates here that it will not, the proceedings will not become invalidated, or the evidence also will not become inadmissible. But compared to the section 4 of the Oath Act, Oath 4 says that a child who is under the age of 12 years, who is capable of understanding the duty to speak the truth, but not able to understand the nature of the oath, those child who is below the age of 12 years need not be administered with the oath, and these provisions are not applicable. The section 4 or 4, that is the mandate of administration of the oath, is not applicable to the child, that is child up to the age of 12 years. I will once again clarify that the child at the age of 12 years, below the age of 12 years, if she or he could able to understand the duty that I must speak truth before the court, that is section in consonance with the section 8 of the Oaths Act. Everyone who is giving evidence shall be bound to state the truth before the court. That is able to, this could be understood by the child. But she is not able to understand the nature of the oath that's been administered and what is the purpose for which the oath has been administered. If this is a case, that child could be exempted from the administration of the oath, and these sections will not, the section 4 will not apply to this child. So therefore, child up to age of 12 years is exempted. Yet, though it is exempted, that evidence is admissible, and her if her nature of the duty towards the court, that is to speak the truth, is understandable to her. This is what has been completely discussed. This is this section 4 and section 8 has been very well discussed in one case by name Rameshwar versus Rajasthan, state of Rajasthan, in 1952. This is by Justice Vivian Bose, Honorable Justice Vivian Bose, Supreme Court case. And please go through the case pertaining to the child witness. Here now we will come to the section. Here, then we will go further here. 118 I have said all are competent witnesses, including the lunatic, child witness and accomplice witness under section 113 and all. The opinion as to the competence of the child, as to the rationality of the answer if it is desirable. So if the child is going to be brought as a witness before the court of law, then the opinion has to be formed by the court whether she could or he could give a rational answer, and an opinion has to be formed, and it is desirable. That's what the judgment says. It is desirable for the court to first to form an opinion as to her rationality of giving the rationality as to give the answers, and then proceed with the recording of the evidence. In cases, this is a case where it says the child witness in all the cases need not be corroborated. In certain cases, it also could be exempted from the corroboration if the child witness completely inspires the confidence of the court. That's a case of child rape, that Rameshwar versus so and so, that the child will be raped by the accused. The child will, with the crying, she will return back to the house. The mother will come after 2 or 3 hours. The child will disclose the thing that has happened to the mother, and thereafter the mother will prefer the complaint. The thing is that the child's statement to the mother before filing the FIR is the at or about statement that is falling under section 157 of the Evidence Act, and whether that statement could be used, the mother deposition or the child deposition, that I made the statement, the girl made a statement to the mother, is at or about the time when the incident has happened, and whether it could be used to corroborate the evidence of the child in the court, testimony of the child in the court. That is what the primary question that's been dealt with in that case. And ultimately the court said, though it could be corroborated, not in all cases corroboration is required. If the victim's testimony inspires the confidence of the court and it gives a sufficiency and weightage to convict the accused. Only in case where if does not inspire the confidence and it creates some little doubt about that case of the prosecution, then the court can look for the corroboration from the independent sources for the purpose of strengthening and giving weightage, for the purpose of giving strength to the substantive piece of evidence which is available which is available to the court to effect the conviction. This is what has been discussed in this case, Rameshwar case. And 118 said all persons, I have said that all persons are competent unless not capable of understanding, from understanding and giving the rational analysis by means of the tender age, extreme age, and disease, body and all. This is what has been given in this chart. I will go further in the chart. That is, it's a lengthy chart, and we'll discuss the section, and once again we will review this. We'll come to the chart for the purpose of better understanding that.
Sir?
Yes, madam?
We are nearing 8:30, sir, now.
It's another, I require another.
We have for one, how many much time you need, sir?
I may go up to another half an hour, madam, just at least required. This
So
is
can we have it as one more session, sir? Because from morning we are having the sessions. This is the third session. Can we have a short session sometime this week at your convenience? Because
Okay.
a few of the participants has personally messaged me because tomorrow is a working day.
Okay. Because this.
Sorry to interrupt.
No.
I know we'll have a short session sometimes before the examination. We'll work out it and we'll decide.
Okay. Then we'll hold up to this witnesses. We'll proceed from chapter 9 and 10 the next session.
Yes, sir.
Okay, madam. Thank you then.
If anyone has any questions, post it in the chat box. It was a very excellent session, sir. It was just like a song. It was just sorry to interrupt because a few of the participants who have been tomorrow being the working day, few wants to get connected. That's why. Otherwise, had it been a holiday tomorrow, we would have extended. From morning we started, sir. From morning 10 o'clock we have been connected. This is the third session, and that's why, sir. Sorry.
No, madam. No.
Getting correct. Thank you, sir.
We'll take one more session, madam. No issue.
Yes, sir. Friends, we